All right, the next case on this panel's list is 250326, Jay and Lori Strait versus, is it Hagie? Hagie Manufacturing Company. Mr. Russell will be arguing for the Straits, and Ms. Hempy for Hagie Manufacturing Company. And as soon as everybody gets set up and you're ready, Mr. Russell, we're ready for you.
Court, opposing counsel. My name is James Russell, and I represent Jay and Lori Strait in this matter. This case really boils down to one issue, one decision. Did the Supreme Court's holding in American Fire, is it still good law? Or was it a mere 17 months later abrogated in Detterman? You don't have to trust my word to determine that. Go read Detterman. Note how Detterman cites multiple times American Fire. Note how Detterman discusses that it is using the analytical framework of American Fire to decide its case. And then decide, did Detterman abrogate American Fire? Once you've made that determination, there's no conclusion you can reach besides reversing the summary judgment ruling of the district court and sending this case back down for trial. The facts of this case in American Fire are just too similar. American Fire involved a Ford truck. This case involved a Hagie sprayer.
One fell apart and one decided to burn up. Isn't that somehow different when you're looking at words like dangerous and sudden? And
One involves a fire and one involves a collision, but both are handled by tort law. In American Fire, some sort of defect, not specifically discussed in the case, allegedly caused the truck to catch on fire spontaneously. Here, while driving in a field, the sprayer crashed. We've heard multiple times in the briefing at the lower court that it,
axle fell and stops dead in its tracks. That was one of the things I was trying to get my head around too.
the first thing to understand is, and I don't know your background in agriculture, Your Honor, so I will try to give a little.
A lot of background in vehicles and vehicles doing stupid things and not working properly. I have a lot of,
I think we all have a little too much background in that. But what's important to recognize is there's a lot of difference between maybe just a regular car on the street versus a sprayer. A sprayer is extremely high up in the air. So when it falls to the ground, it's not just a matter of, skidding to the ground. It is falling a significant distance to the ground. And it wasn't just a mere, the axle broke and it sort of went off kilter. This thing fell to the ground, parts of the leg assembly crashed into the vehicle cab itself, as did the suspension airbags. And it caused over $100,000 in damages to the sprayer, not including the leg assembly, which Hagie ironically paid for. $100,000 to the sprayer and the booms, as well as damages to the chemicals. Consider an analogy. If you're driving down the street and let's say there's a defective hood on your car, and that hood crashes through your windshield into you, even if you avoided injury, I think you would still classify that as a violent collision as opposed to a mere breakdown. They make it sound like this sprayer just broke down on the side of the road. That is not what happened here. If your Honor wants further clarification onto that issue, go read the deposition transcripts. Read the deposition transcript of the son who describes the accident himself and describes these things, he's not sure what, coming into the cab. and then read the deposition transcripts of Mr. J. Strait, who came upon this accident that his son had just involved and the violence that was involved in this collision. So while one's a fire and one's a collision, both are best covered by tort. Both cases did not involve any external objects. We know in American Fire that there were contents in the truck that was at issue. In this case, we know that the chemical load spilled out onto the ground and was contaminated and could not be used. And we also know that the booms, which are a separate attachment that are included onto the sprayer, were damaged in this accident. Both were foreseeable, or neither was more foreseeable at the time of contracting. You'll read in their briefs, a lot of times they even cite American Fire for saying, well, look, it was foreseeable that the sprayer would break down and not work anymore. That's not what we're talking about here. When we're talking about foreseeability, we're talking about a product not working as it's supposed to.
Dieterman, though, cites American Fire and says permitting tort recovery where defect causes sudden and dangerous occurrence, not only to the product, but to other property as well. Are you saying that other property was damaged here other than the entity we're talking about?
Yes. So in in American Fire, which, by the way, that quotation that you're just discussing, I don't know if you're quoting it exactly, but look what case is cited for it. American Fire. Is citing American Fire. American Fire, it was the truck and the contents within the truck. In fact, by the time it got to the district court, they were only pursuing the truck damages itself. Here, this is actually distinguishable because not only are we pursuing the damage to the sprayer, but the sprayer booms were also damaged, as were the contents, i.e. the chemicals of the sprayer.
How is that not all one thing?
You can look at it a few different ways. One would just be to sort of say, hey, if you take the chemicals out of the sprayer, it's still a sprayer. You take the contents, if you take individual parts.
One, oh.
As I sort of wanted to joke, so if I'm sure, recognizing how strict companies like John Deere and Hagie have been with their manufacturing, I wonder whether they would agree that if the spray that was sprayed in the sprayer no longer or didn't work properly, was that covered under the warranty for the sprayer? The obvious answer is no. They're different.
Like, I'm imagining that these booms are things that stick out the side that the stuff comes out of, or no?
It's important to understand that they are an attachment that's added. So I am not a farmer myself, so I'm trying to understand this a little bit.
Spray without the booms.
The sprayer cannot spray without the booms, but you can have different types of booms installed. It happens in this case that the booms that were sold at the same time the sprayer was purchased by Agriland FS was these booms. But there's nothing that would prevent this facts from being distinguishable. It could be any booms that were attached. And while they were bought at the same time, they were a separate line item. They're more equivalent to sort of like an aftermarket part that you would add. Maybe even if you bought it at the same time as your car, nonetheless, it's different than your car itself. In the end, both cases involve a sudden and dangerous occurrence resulting in a genuine hazard from a product defect, and both are best addressed by tort law as opposed to contract law. I would encourage the court to compare the facts of American Fire with the Detterman case and see how American Fire and this case is distinguishable from Detterman. Detterman involved a house. At the time that the claim was brought, the house had defective conditions which led to a sagging roof, cracks in some of the walls, and moisture spots. But importantly, the house had not collapsed. We weren't dealing with a sudden occurrence. We were dealing with a situation that developed over time. The court recognized that Dieterman's expert said a risk is that this house could collapse. But the court said, look, that is but one of several interrelated factors that we look at. And we look at the manner in which the risk arose. We look at the type of injury that caused, the nature of the defect. So while it's true that all three cases, Dieterman, American Fire, and our case here today, involve a type of risk, a defect that could cause a crash, that case is distinguishable from the case. I see my time has expired.
It's on rebuttal, thank you. And we'll get into that when you get back.
Katie Graham for Hagie Manufacturing Company. This case is about whether Iowa law allows a party to circumvent their contract just because their contract remedies have run out. The answer to that question under decades of Iowa precedent is no. The plaintiffs in this case cannot use tort law to gain a commercial product warranty they concede they do not have in contract. We've addressed two issues in our appellate brief. I want to start with the first issue. The second issue is an alternative argument if the court finds that the plaintiffs have generated a dispute of fact on this argument that there is other property. But the first issue relates to whether the economic loss doctrine bars plaintiffs' tort claims altogether. And I want to get one thing straight that was raised by opposing counsel. There's absolutely no support in this record that there was a crash. There was no support in this record there was a collision. Jackson Strait was the only witness to this incident. He was the operator of the sprayer. His father, Jay, later came upon the incident after it occurred, but Jackson testified that the sprayer's leg popped and it fell to the ground. That's all that happened here. Under the economic loss doctrine, decades of Iowa precedent supports that there at least must be damage beyond the product itself in order for a plaintiff to even contemplate bringing tort claims, right? So we've heard a lot of argument today about American Fire. The plaintiff in this case wants you to think that American Fire was the Iowa Supreme Court's last word on the economic loss doctrine, but it wasn't. After American Fire, we had the Dieterman case, which was just a year later. And the Dieterman case said, notwithstanding our adherence to that multi-factor test, looking at the type of risk, the nature of the alleged defect, and the manner that the injury arose, there's a threshold test before you even get to that multi-factor analysis. And there must be damage beyond the product itself. If there's no damage beyond the product itself, recovery is barred in tort, and the plaintiff must bring contract claims. That's exactly the case we have here. Now, the plaintiffs have claimed that chemicals within the sprayer and the booms to the sprayer are somehow separate property from the sprayer itself. And I think the court has picked up on our argument here that where does that end? That argument would completely eviscerate the economic loss doctrine. Clever plaintiffs' counsel in any case is going to find some integral part of the product itself and claim that that is separate property to get around the economic loss doctrine. That is a result that I believe the economic loss doctrine cases would not endorse in this case. And so Hagie is not asking this court to find that American Fire has been overruled. The cases after American Fire merely clarified what the analysis is, that you first need to have damage beyond the product itself. And in fact, both the majority and the dissent in the Eighth Circuit Floyd County case agree that that is the standard in Iowa law, including the dissent, which is advocated for by the plaintiff, that there must be damage beyond the product itself. The plaintiff has advocated that there's a fact dispute, whether there is damage to other property, and advocates for a few different tests the court might apply, but they must present admissible evidence as the party resisting summary judgment that there is separate property. They failed to do so on this record, and whether or not there is separate property from the product itself, I would submit to this court as fairly self-explanatory. It's either part and parcel of the product, or it's some other property, or there's personal injury apart from the product itself, and we have neither here. I also do just want to clarify that, again, under that American Fire test, the Plaintiffs' Counsel has advocated that the test this court must impose is whether or not there was a sudden or dangerous occurrence. And I have two responses to that. First, whether or not there was a sudden or dangerous occurrence is not the economic loss doctrine test. The economic loss doctrine test is that multi-factor analysis the court set out initially in Nelson. The court in American Fire merely said those types of cases that lean towards tort cases may involve sudden and dangerous occurrences. But whether or not there was a sudden or dangerous occurrence isn't the test here. Secondly, we would submit that this record does not support that there was any such sudden or dangerous occurrence. Again, the testimony of Jackson Strait was that the leg just popped and it came down in the field. It didn't collide, it didn't crash.
Say, just decide that the booms and the chemicals within these sprayer were all a part of the sprayer, is that the end of our analysis, or do we still need to go back and address the multi-factor and the American Fire holding?
I believe that's the end of the analysis. I think under the Dieterman case and then the cases that come after it, we've cited to Annette Holdings and the Des Moines Flying Service case, all say that that's kind of the threshold inquiry. Is there damage beyond the product itself? If there is not, the court's analysis can end there. If there is, then the court would consider, well, is this still a type of contract expectation, weighing those factors, or is it that safety insurance policy of tort? So it's our position that here, because those are part and parcel of the product itself, the court's analysis is fairly straightforward. The economic loss doctrine applies and recovery is barred. The Plaintiffs' Counsel in this case has made some arguments about what ifs, what could have happened. The sprayer's booms could have been manufactured by another company. Someone could have been injured in this case. The fact of the matter is that's not the facts of this case. That's not what occurred. And the economic loss doctrine doesn't allow this court to consider hypothetical risks. And my opponent cited to that Dieterman case, and in that case, the court specifically found where a risk had not come to pass, where the house had not collapsed, the court couldn't consider the fact that a hypothetical risk might occur in a different case. That is not enough to bring it into tort. So that is not enough in this case, and their claims lie in contract.
If you've had any opportunity or know about the Zeal versus Energy Panel structure case that a panel of our court decided in 2020, where a building collapsed and they determined the economic loss doctrine would apply. Do you have any comment on that, or maybe I'm just putting that on you right now?
We cited to it at the district court level, and I will be honest with the court that it was not on the top of my list to review for this case. We cited it to the district court for the proposition that that post-sale duty to warn analysis shouldn't be treated differently. So that's what's coming to mind. And apart from that, I will be honest that I can't speak further on it.
I'm just curious.
And lastly, I just briefly want to address our alternative argument that even if the court were to find there was a fact dispute, whether there is other property as the chemicals or the booms, that we would argue that the plaintiffs are still foreclosed in this case from recovering the damage to the product itself. So their damages would be limited to just recovering those chemicals and potentially those booms to the extent they could prove that damage at trial. that's that issue of first impression that was decided in Floyd County. I don't think this court needs to reach that issue, but that is our alternative argument. And seeing there are no further questions, we will ask that the court affirm the ruling of the district court granting summary judgment in Hagie's favor. Thank you.
Go look at the deposition transcript. I'm going to do one for you and just read it to you here because I heard it multiple times about it just popped. The question was, and can you describe for me basically what happened with the sprayer? Answer, I was coming down the hill and it just popped. It just went down. It was really no what happened at all, I guess. Okay, when you say popped, what are you referring to?
Transmission drops. Drops. Is that the same thing, or does it have to be like the whole, are you gauging this inquiry into how much damage the breakdown causes?
I think it's the nature of what the accident happened. A transmission dropping doesn't involve a risk to persons. I mean, are you talking about a transmission from a sprayer about falling down? It's not going to involve damage to persons or property. Mr. Stray's son also fell with the sprayer. Now, he wasn't injured, but it goes to the point of the dangerous risk, or as I was going to get to the next line, he talks about the axle breaking and something popping into the cabin that he was in. This wasn't just a breakdown. It's insulting to say it was just a breakdown, frankly. It was lucky. You know, in their case, they talk about a windfall. It was lucky. They have the windfall, the fact that Mr. Stray's son was not hurt. Jackson Strait was not hurt. But nonetheless, this did involve damage to beyond just the sprayer itself. There is no difference between the contents discussed in the truck in American Fire and the chemicals contained in the sprayer here. Both were damaged, one in a fire, one in a collision, and both have recovery. And under American Fire and the doctrine of stare decisis, that means that you can go after both the damage for the product and the damage for those other items, in this case, the lost chemicals. I mentioned, and I sort of cut myself off earlier when we were discussing, there's a variety of ways that you can distinguish the chemicals. I mentioned, you know, whether the sprayer still remains a sprayer. I talked about thinking about the warranty, and obviously we wouldn't expect the warranty to cover. Another way to look at it, though, is it sort of depends on the nature as well. It's all, you know, they discuss these various factors. They're all interrelated and they come together. It's frustrating. You want to find out, well, what's the definition of nature of risk or type of risk? And what's the courts don't have it because they're interrelated and they're all discussed at the same time. And that's true as it relates to what is and is not part of the sprayer. If this loss, they want to talk about hypotheticals, if this loss had simply been the sprayer did not perform as expected and the sprayer dumped chemicals, you know, in a line instead of spreading it out, I would agree with them that the chemicals are part of the loss. There's no difference between the chemicals and the meat that did not cure in Nelson. But that's not what happened here. There was a crash and the chemicals dumped out. And
Some of the factors that we have to look at, and you've spent a lot of time on the manner in which the injury arose. It's a big crash, da, da, da. But what about the nature of the defect? What do you say to that? What was the nature of the defect? Because here, they did a product improvement plan, you know, that your folks didn't follow up on, right?
well, that's actually a factual issue, and I don't think it's one that they say they don't need to reach. Our clients don't recognize
The defect?
the nature of the defect, which they clearly recognize the fact that they were doing the product improvement plans. They saw that there was a risk. It wasn't they were worried that these sprayers were going to break down. They had a contract that covered them on that. They were concerned.
your statement of that, doesn't that more go towards what happened in Dieterman than what happened in American Family?
What I was going to say is that the fact that they had a product replacement plan or improvement plan is because they knew that there was a risk, that this was a safety risk. It went beyond that these sprayers are going to start breaking down, and they were concerned that these sprayers were going to break down and start hurting people. And so they had to fix that.
It's the kind of situation where contract law provides the purchaser's expectation interest that the product will be fit for its intended use, like Dieterman cites?
Dieterman, I'm running out of time here. Yeah. Dieterman involved the same type of risk with the house collapse. The difference was, in Dieterman, the house didn't collapse, so all we were talking about was things that occurred over time, sagging roof, cracks. Here, the accident happened. Just like an American fire, the fire happened. Thank you, I've run out of time, thank you.
And thanks, counsel, for the excellent briefing and the arguments today. My colleagues and I will consider 250326 submitted, and we'll get a decision out to you folks as soon as we can. Thank you very much.